Let's get some analysis now. Mpumelelo Zikalala is a legal analyst and joins us live now. Thank you so much for your time. I suppose then this particular ruling means that these confessions are now going to form part of the record. So what does it mean for the case going forward?
Definitely, Manetta. Good evening to you and also to the viewers. It means that this particular piece of evidence can now be accepted so it can be evaluated at a later stage with all the other pieces and information that has been submitted to the judge. And its probable value is going to be evaluated, its accuracy value will be evaluated, and after all, it will all come back to determine, have the state provided reasons to prove that the individuals that are in that box are indeed guilty beyond reasonable doubt, and there's no other explanation in the submissions that have been submitted by the state that will be able to prove that indeed they are the ones that killed Mr. Senzo Meyiwa.
So we heard some names then being mentioned as some of these statements were being read out and, this trial within a trial continuing. Can we now, say that some of the names that were mentioned in those particular confessions, we can expect to see some of them as witnesses, possibly in court?
It will be up to the state as to what strategy do they want to move in. But remember, the state must be able to show that what motive was there in order for these individuals to do this, alleged to do this, the crime. So at the end of the day, they have to come back and say, this is how this individual is pitching in. This is why we do not pursue any prosecution against this person. And then if the state doesn't do so, definitely the defense is going to come on board and seek to discredit whatever submissions would have been made by the state. And I think the defense, by the way, is going to take this matter lying down. Because if you look at the Criminal Procedure Act that determines how these criminal proceedings are supposed to be, these are section 317, that there is special entries of irregularities or illegality, in which they may come back and say, Honorable Judge, yesterday when you gave a judgment, you did not go to town and further explain to us as to what elements did you look at in arriving at conclusion. What doing is putting us in a very in disingenuous space because we do not know what to fight and what not to fight. Can you please provide us those reasons? And if after you have done so, then you can be able to decide whether you want to appeal based on this irregularity that's taking place or the mere fact that you've chosen to accept this evidence. Because by doing so, we are basically giving 80% of the case to the state, and there's nothing really that they'll need to prove except in proving that all the technical requirements in terms of the collection and the submission of the evidence, other than the confession has been done correctly. So you are basically saying the state has won its case before we've even gone into the witness box and provided our own explanation.
So can we now see a comparison, for example, in what the accused said in court versus what is contained in their confessions as the case continues?
It can be that maybe they did not understand what exactly they were getting themselves into when those confessions were being signed, which is the most important part, by the way, because that is why you need a legal practitioner to be next to you. That is why a confession is done in front of a magistrate and not a police officer, so that you can be able to understand and comprehend.
Kuzeni? All right, it looks like we lost Mpumelelo Zikalala there as we were getting that analysis on what was, happening in court, and you heard them, Judge Ratamukhatleng, saying that these confessions were made freely, they were made voluntarily. That's his judgment there in that particular matter. And Kuzeni, I do understand that you are back now. We're talking about the possible comparison. Will we see it when the case, as the trial continues, that the accused version contained in the confession statements versus what they would then say in court? Can we see a comparison in that regard?
Definitely, I think we're going to see it, because what the defense is going to try and do now is to make sure that the record reflects that the confessions that were taken earlier ought to have been disregarded by the court. And it was actually a mistake by the court to accept them as it has done now. You are doing that for two reasons. Trying one last time and get a second chance and convincing the judge that you should be found not guilty. If you fail to do that, make sure that the appeal record is fully set and contains all the important information, so that when you take this matter to the SCA, the judges that are going to be there are going to say, the judge, if we were judging this matter as a court of first instance, we would not have accepted this piece of information pertaining to the confession as evidence. Secondly, if you look at it overall, whether you have it or you don't have it, there is some reasonable doubt that is found here and there. Hence, this particular individual should be found not guilty.
So then, is this the end of the road then for the defense, or do they still have legal room to be able to challenge this particular ruling?
It's not the end of the road. There are still a couple of options that are available. The first one is to use Section 317 and say that there's a special entry of irregularity that would like to highlight to the court and let the court deal with it. But you need to request the reasons of why the court ruled in the manner in which it ruled in today, so that you're able to make a comprehensive application to it. The second part, you can then say, after the end of the state's case, I'll still put in my Section 174 with my reasons, and then hear what the court is going to say in the last one. It would say, let's go up until the end of the trial. I'm going to have my clients go into the witness box. I'm going to provide external witnesses which are going to be able to dispel or dispute what the state has stated, either within the trial, and also within the main trial, because I want that piece of information to form part of the record, so that if I'm found guilty and I'm taking this matter of an appeal, all the various elements that ought to be looked at by the courts that are going to assist in me getting the not guilty plea are going to form part of that record that will be utilized later.
All right, thank you very much for that analysis. Appreciated. That was Mpumelelo Zekalala, legal analyst.